My name's Peter Wainman. I'm a lawyer and I'm a partner at the law firm Mills Reeve, and I specialise in technology and data. So we've helped in three key ways. The first was we talked through with the Zircon BeTalent team what they do with personal data, and particularly the balance of what they do against what their clients do with data, and how data sharing works between Zircon BeTalent and their clients. So that helped us analyse who's a controller, who's a processor in terms of those data flows, and identify some areas for addressing in their engagement with their clients and in their contracts and in their other documents. The second thing was then, based on that analysis, we looked at what they should put into their privacy notices to individuals, and to explain to them how the data that's collected through BeTalent and other means would be used by BeTalent, by Zircon, or by their clients, depending on the circumstances. And in particular there, we were looking at addressing the difference between the circumstances where Zircon would be using the data itself as a consultancy to provide, for example, coaching to individuals, and where it would be giving the data back to a client for the use by their client, HR, line management teams, and being very clear about the distinction between those two roles in terms of what we said in the privacy notice. And the third area was also, we looked at the rules around profiling and automated decision making, which under the GDPR is more complex, and both in terms of what you tell people around how those decisions are being made through, for example, talent management processes, looking also at data protection impact assessments, which usually led by a client, but nonetheless, again, Zircon BeTalent being able to have the right conversations with clients about those issues and what they should be considering in going through a program. So I guess those were the three key areas where we helped. I think we've also then helped with ad hoc questions, where for particular client engagements, based on the approach taken by a client, based on their own data protection policies and processes, the Zircon BeTalent team have wanted to make sure that they are answering the due diligence questions that they're challenged rightly by their clients about correctly, to make sure that they're, for example, security procedures and so on are appropriate in the context of the questions they're being asked, and that they are confident in being able to say, yes, we are GDPR compliant, we have a GDPR compliant product when they're asked those questions. So this is a challenging one that we've seen for a lot of clients at the moment, in that there's so much uncertainty. We don't know whether there will be a Brexit, and if so, whether it will be a with deal Brexit, in which case we don't know which deal, or a no deal Brexit. So from a legal point of view, it's very difficult to give a clear answer on what the outcome's going to be. So the conversations we've had with BeTalent and Zircon have looked at, for example, data flows between the UK and the EU, and what businesses should be doing to get ready to legitimise those data flows, for example, in terms of use of standard contractual clauses where appropriate. And also, again, being ready to answer client questions and concerns about the way the BeTalent product is still going to be usable in the context of a post-Brexit world. And in most cases, we've been able to provide the reassurance that in any of the Brexit scenarios, it's unlikely that there's going to be material risk either to Zircon and BeTalent or to their clients, as long as you're doing the right things to prepare, and as long as you're asking the right questions, which clearly you are. So I think the answer is there are some challenges around Brexit, but no reason for panic, and I think it's certainly a case of being ready to adjust based on the sort of Brexit we end up with, if that is what we end up with.